And what has happened over the course of this case is that there have been flurries of extrajudicial statements attributed expressly, quite unlike, for example, in the Flemmi case that we offered to the court as authority, quite unlike a number of the articles in that case, which were just attributed to blind sources, is that they're attributed to law enforcement sources or law enforcement sources connected to the investigation. So here the court can do something, and what we are asking is something very modest, Your Honor. We are not here today to weigh and make findings as to whether or not the defendant was prejudiced by these statements, though we believe he was. We are here today to vindicate a right that lies at the core of our motion and lies at the core of our process, and that is that Mr. Hernandez is entitled to a fair trial. He is entitled to a jury panel that has not been poisoned by either false or sensational statements that come not from strangers or laypersons, but from law enforcement. And to the extent we have received in our opposition what I would call pious denials by the Commonwealth of engaging in this behavior, it really matters not. What we didn't receive from the Commonwealth was any factual information, as in, for example, in the Flemmi case, where a motion similar to ours was met with affidavits that clearly put out in a factual record from dozens of law enforcement agents and attorneys associated with the case that they had not engaged in this practice. Here we have nothing. We have nothing but the bald denials that are set forth in the record, in the opposition filed by the Commonwealth.
How do you respond to the Commonwealth's argument that the defendant is not entitled to any of the requested relief because whoever Sports Illustrated sources were or any of the other sources are not named in the affidavit, in your affidavit?
Well, Your Honor, I would respond quite succinctly. First, I would direct the court to the Flemmi case, which in itself says that a prima facie showing that is required for the relief that we seek is, and I quote, typically based on the press articles themselves that appear in the press. So in the Flemmi case, where the court carefully looked and said this prima facie case also, in the words of the court, is not that difficult to establish. Because what we are putting before the court, what we are showing is that the articles themselves contain the prejudicial information. Of course we can't identify the specific source within the law enforcement community of these leaks. If we could, we would probably ask that the district attorney prosecute that person for contempt of court for a violation of Rule 5D of the Massachusetts Rules of Criminal Procedure for disclosing matters that occur before the grand jury, which includes the identity of witnesses and the subpoenaing of witnesses to the grand jury. So I would say that that is a false argument. It erects a barrier that could never be satisfied by any defendant who is simply trying to put the reins on statements that will accumulate in the public and affect his right to a fair trial. I would further ask, Your Honor, and just clarify one thing, that in the Commonwealth's opposition, the Commonwealth appears to be litigating a matter that is not before this court. I want to say again, we're not here today to establish that Mr. Hernandez cannot receive a fair trial, or that the jury panel has been irretrievably tainted by this conduct. We are here at the early stages of the case, which is supported by the case law. At the early stages, we are simply asking the court to exercise its discretion and act on what the Shepard case and the Flemmi case refer to as a court's duty at early stages.
To the extent that the rules talk about taking reasonable care to prevent law enforcement from making extrajudicial statements that the prosecutor can make, what are some examples, or what do you say would be reasonable care? Well, your proposed order tracks the rule, but I just ask you to tell me what you think are those steps that would constitute reasonable care.
Certainly, Your Honor. What we would like to see, and there is nothing in the record to date, again, contrast this with the very fulsome record that went before the district court in the Flemmi case. We would like to know how the law enforcement team has been apprised of the court's order. What is the extent of the...
That's what's been done, but I'm saying to you, what steps do you think should either have been done or should be done? What do you say is reasonable care?
What I would say is reasonable care in order to rules and by this court's order on the 15th, is that, that on the Commonwealth's side, that the Commonwealth should attest to this court and should attest to the defendant that they have taken steps to apprise every single individual associated, and we know there are a lot of them, every single one, that they have been apprised of the order, that they have been apprised of the rules, that they have been apprised of the dangers to the Commonwealth's case of engaging in this type of behavior and how it could come back and hurt them later. I would think there has to be a record that those individuals have been informed, they have been briefed, and that they have acknowledged that they have a duty. And I would also like to say that reasonable care, in my view, would be that if there was any finding by the Commonwealth of any individual associated with their team that was making these types of statements, that was feeling empowered to go to the press and leak information about the defendant and try to affect his entitlement to a fair trial, that there would be a record of swift and decisive disciplinary action against that individual. Just let me close, Your Honor. I just wanted to say one thing. Again, on the relief that we are seeking, we are not seeking sanctions. We are not seeking anything more than the escalation, one-level escalation of this court's measured and thoughtful order of the 15th to now hold the Commonwealth to the powers of this court's contempt powers, and in exercise of that discretion, to take one more step to assure that Mr. Hernandez receives a fair trial. Every time, in the shadows somewhere, a law enforcement official leaks information about this case to the press, and it then goes viral on the internet or in the print media, the ability of Mr. Hernandez to receive that fair trial is eroded. And I would say the scales tip in favor of the Commonwealth. And so it is the Commonwealth's burden. I'm sure we'll hear that the Commonwealth takes the rules very seriously and abides by the rules and has no idea where these things are coming from. Well, they should find out, because law enforcement sources are clearly what is referenced by the press in these materials, and it is law enforcement sources for whom they are responsible. So we would seek that relief, Your Honor, and I'd be happy to answer any further questions the Court may have.
The proposed order you're seeking would, to the extent the rules impose an obligation on defense counsel as well, would apply to defense counsel.
Absolutely, Your Honor, and we're happy to be subject to those same rules. We have no interest in populating the popular media with information that would deprive our client of a fair trial. Far from it. So we're happy to live by the same rules, but it's not defense sources that are expressly referenced in these articles. It's law enforcement sources. Thank you, Your Honor.
First of all, Your Honor, I would categorically state to the court that there has been no flouting by the Commonwealth or by the investigative team assigned to the case of Aaron Hernandez. After the last time we were in court, I personally met with the people involved, reminded them of the admonishment the court had made, and also just reminded them of their duties in the investigation, which was to maintain the integrity of the investigation and the confidentiality of the investigation.
So who is that precisely? You say the investigative team.
It would be the prosecutors in the case, the lieutenants overseeing the investigation from the state police, the captain overseeing the North Attleboro, and their individual sergeants and officers that are involved in this. There was a very few number of people, despite what my brother would continue to rely on the reports, very few people involved in certain information that's being shared about the investigation. But I reminded them that there's written protocols by each department already in place about their obligations to maintain secrecy in investigations, not to be talking to the members of the press, as well as the district attorney also has similar protocols. But what we see with Mr. Fee indicates this is the third time bringing this. The mere fact that they've raised this issue before does not make the information true. And Mr. Fee knows better than anybody, because back when there was, similarly as he characterized it in the motion, that the Hernandez investigation has, this is his quote, the subject of a relentless flood of rumors, misinformation, and false reports in the media. He indicated that these included repeated publications of supposedly confirmed reports of an arrest warrant that had been issued for Aaron, a report exposed as untrue. He knew back then and was obviously indicating his frustration with what was being put out that was known to us to be untrue and was known to him. He went on to indicate none of the false reports come from official sources, and we appreciate the professionalism and the restraint shown by the Bristol County District Attorney. Now, that later, when the evidence, the trail of evidence led to the arrest of the defendant, turned into then, on the past two occasions they've raised the issue, misconduct by the government.
Well, let's focus on these stories.
On these stories, Your Honor, I intend to deal individually with the exhibits that they've raised. His claim has indicated, again, wild accusations, unsupported, because what he wants the court, what he's asking for the court, is to reach the end to make a finding without any showing of the in-between. And the
make a finding, right? He's asking the court to, as has been true, hasn't it, in many high-profile cases where right at the beginning the courts have issued an order that says both sides have to comply with the rules. Then he indicate today, once again, that he's not asking this court to make a finding, but is asking the court to simply issue an order that orders both sides to comply with the rules. And there are lots of cases where courts have done that.
And I guess what I meant, Your Honor, was he is attempting to connect these reports to some law enforcement person connected to this investigation. We deny that that's the case. And he needs to make that link, or he wants to suggest for you to make that link, so that you can then take further action with regard. We resist that because it's factually not true. There's been no showing. There's not been an affidavit. They've made no effort to try and investigate what they're alleging. And in fact, the requirements of the rules to provide an affidavit with personal knowledge, they've totally just sidestepped that, and like they've done on a prior occasion. This is the second time they've engaged in filing a motion alleging prosecutorial misconduct, and they did it before, and when we received it, we actually investigated and found out, again, there was no affidavit attached. We went, investigated, located a person who actually had personal knowledge, had him file an affidavit, showed attached as an exhibit a voluntary consent form of the witness, totally refuting their accusations about misconduct in the case. So what we're saying is we're resisting it because we have the right to a fair trial. Their comments or their suggestion that we have moles out there leaking information is factually not true, but it's also prejudiced the Commonwealth, because that same jury pool can reach bias toward the Commonwealth if they think we're not playing fair. We are playing fair, and as evidence of that, they cite, I think, 6 separate exhibits. Beginning with exhibit number 2, I will represent to the court information contained in exhibit number 2 is not accurate. And
so the statement that Pouncey was served with a summons to appear at grand jury the Massachusetts State Police served Mike Pouncey with a grand jury summons less than an hour after the Patriots defeated the Dolphins. Is that untrue?
Your Honor, as you know, the matters before the grand jury, I'm not free to comment. I would make a proffer at sidebar with the court ex parte, but I'm indicating that information that is claimed to be accurate is not accurate in that report. And my point is this: if it was somebody involved in the investigation, that would have been accurate. And I'm representing the court, and I will back this up with either a sidebar or a written submission under seal. That is not accurate. Exhibit number 3, also information there that anybody in the investigative team would have known what was true. That is inaccurate. Exhibit number 4, and again, these are just sources, not police sources, just alleged sources with knowledge. Exhibit number 4, also that is attributed to a law enforcement source who actually indicates they're not authorized to speak, which again goes to the, I guess, ultimate issue of whether a further order of the court, if somebody's indicating, I'm not authorized to speak, but I'm going to speak anyways, whether that further order would have any meaning. But that is also not accurate. And again, had that person who claims to be law enforcement, that's not accurate information.
Are you suggesting that when a law enforcement source leaks information improperly, they A, always leak information truthfully, and or B, the media always truthfully, accurately reports what is leaked?
I can't comment on what they do or they don't do, Your Honor. I can just say to you, in this case, this is attributed to an alleged law enforcement. I don't know if that's actually true. What does that mean? What does that mean?
But I thought you were arguing a moment ago because the information attributed to the law enforcement source is inaccurate. Therefore, it did not come from law enforcement. So I'm asking to make the argument that if the information attributed to law enforcement is inaccurate, therefore it didn't come from law enforcement, wouldn't that have to be premised on, A, law enforcement sources who leak always do it accurately, and two, the media always accurately reports what is leaked to them?
And again, I can only speak to the team that's involved with the investigation. That's who I oversee, and that's who I have the ability to control and to enforce the court's order. If somebody from a department in New Hampshire who says, I've been following this, and they're law enforcement, they've been a police officer for 20 years, says, this is what I think, or this is what I hear, we have no way of knowing the veracity of those statements, whether it was fairly reported, anything about that. And there's no way that I could ever promise the court we could keep that type of information from coming in. But what I'm suggesting is, had there been somebody connected to the investigation, all of these exhibits are not accurate. There's not one that accurately chronicles the very things they say they're reporting on.
So, what does it follow from that it was not someone in the district attorney's team? Why does the fact that the statements may be inaccurate prove that therefore it wasn't?
Because I presume if somebody wants to give the perception to a reporter that they have inside information, that they're to be reliable, that they would give the best information they have. Because if it turns out you are being used by the media to give information, and that information is not accurate, they're not going to use you anymore. I don't understand what person would then be providing information unless it was some strategy. And I'm representing to the court, there's no strategy by giving false information to the media. But again, I go back to what Mr. Fee pointed out in the case. There has been extensive media coverage. We understand that. But to the extent that their motion says there's been 100,000 or whatever Google responses if you put in Aaron Hernandez, the best case that they can make that somehow we haven't done our due diligence in maintaining the integrity of this investigation is they say, presumably, somebody tipped off reporters to the matter that happened at Gillette, presumably. And they go on to suggest, then, as if it were now a fact, they say the Commonwealth orchestrated a publicity stunt. That's not true. They resumed a relentless campaign to leak statements to the media. That's not true. Brazen disregard for the court's thoughtful admonition. That's not true. Impertinent dissemination of extrajudicial statements. Not true. And that they then indicate, and this is probably the most offensive, that our representations to the court were at least insincere, that we were going to use our best efforts. So what they are trying to do is stir this pot of misconduct as a desperate attempt to move away from evidence or just keeping the trial of this matter in the court. And they're trying to persuade, Your Honor, and the public to have bias against the manner in which we have done this. That's why we resist it, because it's not true. And the irony that they would make such an argument is that that, in fact, is misconduct in itself. That they would, without any basis, without any compliance with the rule, that they would come before the court and then say, oh, we want you now to tell them and find out and have whatever it is, affidavits, without any showing. And of course, I'm suggesting to the court, I'm making that representation. It wasn't somebody in our team.
And how do you know?
I know.
What investigation was taken after these articles surfaced? Were the people that served the summons interviewed? Was every member of the team interviewed? Were they asked?
I spoke with
sign
everyone
something?
who knew about information relating to the investigation.
And were they asked to sign anything under oath, an affidavit?
No, Your Honor, they weren't. They've all indicated they had nothing to do with it. And I knew they didn't because, as I've indicated, every exhibit attributed, one of which, only one, to the law enforcement source is not true. And that satisfied me as well as what I have seen from the beginning of this case. And a lot more sensitive material has been in their midst, none of which has ever been leaked. And although they continue to go back to this relentless campaign, they've never made one showing that this was connected to anybody other than somebody, because of the media frenzy, a media consultant or some alleged law enforcement source. And so I'm asking the court that, again, that our resistance isn't then viewed because we've done something wrong. We absolutely and categorically deny that. It's they have not made any showing.
Is there any case anywhere that says unless a defendant in a high-profile case produces the confidential source, the name of the source, they're not entitled to an order enforcing the rules?
Well, people are going to report whatever they're going to report. To the extent that that is going to be saddled to the Commonwealth, we can't prevent that. I think that's happened from...
They've asked for an order that applies to both sides that tracks the rule and says, issue the rule as an order. And you've suggested that they didn't comply with the rules of procedure by having enough specificity in their affidavit. They didn't give you the name. They didn't highlight who it is that violated, that gave this information. Is there any case out there anywhere that says if the alleged law enforcement source is not identified in the defense motion, that the defendant is not entitled to an order requiring all parties to comply with the rules of professional conduct?
I'm not aware of a case, but clearly they could take steps to bring that person in. There is a person who has written the article, and this is a courtroom where they could subpoena them, bring them in, have them questioned, as opposed to immediately what they want to do is say, somehow this is the Commonwealth's doing. And that's not supported by the evidence of the case. That other case I referred to you, that they did the same thing, submitted an affidavit leading the court to believe there was all this misconduct, when it was investigated, which they haven't done one thing to investigate either case, it turned out to be a falsity. That we submitted affidavits by a person present under oath who totally refuted everything that was alleged. There was no affidavit. But again, raising it and making this big fanfare about misconduct is prejudicial to the Commonwealth. And that's why they should be bound by the same rules we would. If there's evidence they want to put forward or there's an inability, they can bring that person in and the court can inquire. Who made that?
Don't courts fairly routinely issue these kinds of orders in the absence of a confidential source being identified, in the absence of a hearing where reporters asked to reveal a confidential source? Aren't there dozens of cases where courts have issued those orders without any such hearing? In fact, can you think of one case where that kind of hearing was required in order to get a future-looking order, not an order for sanctions?
Well, every case, if somebody is going to refuse to answer questions, they have to be presented. I don't know that we just anticipate that would be the result. I don't think...
I'm asking you, aren't there dozens and dozens of high-profile cases where courts have issued forward-looking orders ordering parties to comply with the rules of professional conduct without first having a hearing as to what's happened in the past, without where there's been no request for sanctions, but a forward-looking order. Is there any case that says you can't issue that kind of forward-looking order without first making a finding that one or the other side has in fact already violated the canons?
Absolutely not. We've agreed to that order, that we are abiding by
the rules. I thought you were objecting
yes.
to the issue of an order.
I'm talking about the rules of professional conduct.
I understand.
That is what is in play right now, in place. So as to the additional order, we've had this conversation, and the order proposed had additional desire to render opinions as to the outcome of the case, which we objected to. So we've agreed to the rules of professional conduct, and we're abiding by those rules. And
do you agree that the rules at this point could be turned into an order of the court?
Absolutely, Your Honor. I mean, when I directed the people in the investigation, I said, it is now, the court has admonished us that we are bound, as we are anyways, but that you as our agents are also bound by the same rules.
So at this time, there's no opposition to the defendant's proposed order, paragraphs 1, 2, 3. Let's see. Proposed order 1, 2, 3, 4, 5. So 1 through 5, there's no opposition?
Your Honor,
Is that the Commonwealth's position at this time?
I don't have the order in front of me, Your Honor.
So,
1 through 5. May.
Yes, Your Honor, we agree to that.
Thank you. A few other questions on, you indicate the reports are almost entirely cumulative of material already in the public domain. That's a quote from your brief at page 3. Is there any place you could point to me in the public domain prior to the Sports Illustrated story that indicates that there was a grand jury investigating interstate gun trafficking?
Again, Your Honor, I'm not comfortable.
No, I'm not asking you about anything happening in grand jury. I'm asking you for the public domain reference. You indicate that that was already in the public domain. So whether it was true or not, where in the public domain did the stories about gun trafficking appear prior to the Sports Illustrated?
There have been representations in court about where the firearms came from. That's been done on a number of different occasions.
Was there ever a representation in court? I assume there wasn't, because you started off by saying there are ongoing grand jury that you didn't wish to discuss. Was there ever a public domain reference in a public open proceeding to whether or not there is a ongoing grand jury looking into whether Mr. Hernandez was involved in gun trafficking? And if so, where? Since your brief states that
the substance of the brief.
The reports are entirely cumulative of material already in the public domain. So
right. Meaning the substance of the guns and where their origin was and how they came to Massachusetts. And I believe it was defense counsel on a different defendant, co-defendant, who made the representation that this was related to gun trafficking. That's what that refers to, Your Honor.
And
but again, the characterization that's been referred to in the news reports are essentially a summation of what has been put out in terms of the location of the guns, where they originated from, and how they made their way to Massachusetts.
Right, but the notion of a grand jury investigating gun trafficking was not in the public domain.
Again, Judge.
Well, it's not in the public domain. I'm asking you what was in the public domain, not what's
We've
true.
never said anything about what the grand jury is doing or not doing.
And you also say that the matters that the reports relate to are too attenuated from the charges at issue to have any significant effect on the defendant's ability to obtain a fair trial. If there was any evidence of interstate gun trafficking by the defendant, are you stating that this would be information the Commonwealth would not seek to introduce at trial? I'm just asking you about your statement in your brief.
Your Honor, when I made my original bail argument, there was information that we would seek, and again, it referenced the guns coming from Florida. So absolutely, we would.
So what do you mean by the statement that quote, the reports relate to matters too attenuated from the charges at issue to have any significant effect on the defendant's ability to obtain a fair trial? What does that mean, that they're too attenuated?
It refers to a separate investigation, Your Honor.
Just because because it's a separate investigation, it's too attenuated to have an effect on the defendant's ability to obtain a fair trial?
The investigation, again, because of the matter of others, okay, that would be attenuated from the defendant, at least in that respect.
So, to the extent you're now agreeing to paragraphs 1 through 5 of the order, I assume you're withdrawing your argument that by this order the defendant has sought to enlarge the Commonwealth's responsibilities beyond those currently recognized by applicable law?
Correct, Your Honor.
So that argument is withdrawn. Okay, I will take the matter under advisement. I will...
Your Honor, could I just have one moment to confer with Ms. Mike?
May.
Well, that would be all, Your Honor.
Thank you.
Thank you.
I'll allow one of you to respond. But I will, with respect to this order, give some thought as to whether the court may include some degree of specificity as to what are quote-unquote reasonable steps. But I will issue the order with some additional language, since at this point there is no objection. I don't know if you want to speak to, however, the reference to gun trafficking being in the public domain and having been put into the public domain by the defense in any prior argument or anything else that responds to...
Certainly, Your Honor. If I may speak from counsel table, we disagree. And of course, what we have done, Your Honor, is put before the court in proper form through an affidavit that complies with the law and the case law that is applicable in the Commonwealth, in particular the Fleming case, which speaks about a moving party's burden establishing a prima facie case is relatively light. The determination is typically based solely on an assessment of news articles. That's the law. So to be accused of putting an affidavit in that somehow is a violation of the rules of professional responsibility is not particularly something that happens to me at all. So I would say we have complied with the law. We've put the proper amount of facts before the court. The Commonwealth has put no facts before the court. They have put no affiant before this court, not even themselves, to attest to any facts. So in particular, that fact, Your Honor, why wasn't there an affidavit that was detailed that would, under oath, speak to those factual matters? There was none, and I think that speaks volumes. But having said that, Your Honor, we are content with the Commonwealth's agreement of paragraphs 1 through 5, with the understanding that the court may add some specificity on reasonable care. There's no need to address it.
Right. I would actually ask that both of you make a submission as to proposed language that would speak, first of all, to attorneys, the attorney's obligation that both of you have, and second of all, the specific obligation that the prosecutor has under Section 3F as to what steps are reasonable, in part so that it's very clear, so that we're not back here arguing about whether the Commonwealth did or did not take reasonable steps. What steps are reasonable? Really look at there's some literature on the issue as to exactly what, and so I would entertain from both of you proposals to flesh out the order, the paragraphs 1 through 5, both with respect to lawyers that would apply to both sides, and also suggestions from both of you as to the special additional obligation on the prosecutors under the rule. And then I will...
We'd be happy to make that submission, Your Honor.
A period of time, I understand it's the holiday season, that you would like to make that submission by, both of you.
Your Honor, may we respond to counsel's statements about the affidavits and the motion itself and the scope of the...
Well, I think you've dealt with in the brief, and Mr. McCauley argued it if there's something brand new, but I don't...
Well,
at this point, the Commonwealth has agreed to the order and
well,
what you mean?
Mr. Fee made the allegation that somehow we were remiss in failing to include a detailed affidavit. The reality is he's the moving party. Rule 13A2 was clear that an affidavit based on personal knowledge is an absolute requisite for a pretrial motion of this kind. There was no affidavit based on personal knowledge. Mr. Fee has no personal knowledge of any of the material contained in the affidavit. So that is under the rules a grave legal defect, Your Honor.
Do you think a defendant cannot move for this kind of order without providing the name of the source?
You asked for a case, Your Honor, and indeed the Fleming case upon which the defendant has relied makes it clear that it was in fact, A, there's a prima facie showing requirement, and in order to make the prima facie showing, you need to show that there's accurate and detailed information injected into the media stream from sources reasonably attributable to the government. And in this case, that simply wasn't accomplished.
The defendant would not be able to make a showing that the information is accurate. I assume if there's an ongoing grand jury, the grand jury has is everything with respect to the ongoing grand jury, if there is an ongoing grand jury, being shared with the defense? Is the defense getting advance notice of witnesses being subpoenaed to that grand jury, Mr. D?
No, Your Honor.
And have you already received transcripts of witnesses before that grand jury?
No, Your Honor. We were told by Mr. McCauley on October 8th that the grand jury investigation with respect to Mr. Hernandez was terminated.
Thank you. So it would be very difficult, would it not, for the defense to meet...
I disagree, Your Honor. I mean, and in fact, the Fleming case, which they cited in their submission, made it clear that in order to make the prima facie showing, the defendant needed to indicate through the content of the material released. I'm not saying they need to reveal sources or have names, but through the content of the material release, that it is susceptible to the interpretation that government attorneys or agents thereof were the source of the information requested.
And when the articles refer to law enforcement officials...
There was one reference to law enforcement officials. All of the citations they gave, they were primarily sourced to unnamed sources or sources familiar with the underlying events, which may well have been the parties involved. And in one article, I believe, there was a vague reference to a law enforcement source not authorized to speak, suggesting, of course, that we are doing a good job of policing our agents, and the message has gotten across that you aren't authorized to speak.
Your Honor,
so the Sports Illustrated story refers to law enforcement officials regarding Mr. Pouncey as a material witness who could advance their case.
Yes, and
It would be Exhibit 2, Your Honor, the CNN story, according to a separate law enforcement source. It would be Exhibit 4, Your Honor, says a law enforcement official said today.
Once again, we are proceeding by affidavit, by black and white written documents put before the court. This is winging it on the facts, and it's wrong, as just exposed. I would rather the Commonwealth proceed by black and white papers submitted to the court, which can be tested and which can be refuted. But what we're doing right now is fanciful. So we will be happy to submit, Your Honor, a description for the requirements of the order within 2 weeks if that satisfies the court.
And what should we submit, Your Honor, relating to the scope of the order? We've requested
You've
several
already
times at
agreed,
these hearings.
you both have agreed to paragraphs 1 through 5. Paragraphs 1 through 5 track the rules which use words such as reasonable steps. What I would like the order to do, if you would like to participate, I'm not requiring either of you to file anything, but the court would find it helpful so I can spell out exactly what those reasonable steps are along the order that Mr. McCauley has already indicated he's done. Reasonable steps may include speaking to people, sending them written notices, requiring them to sign that they have read and understand, warning them of consequences should they be found to have leaked any information. I don't know, which is why I'm asking counsel to give some thought to it, and then the court will give a greater thought as to spell out what the rule itself says, the rules, and there's commentary on the rule, and there are law review articles that where people have commented on what the rule requires with respect to a prosecutor dealing with law enforcement. I am sure that you will, both of you, will find material that may be helpful in spelling out something with greater specificity than the rule. There is case law that indicates that an attorney's obligations varies with the type of case, varies with the amount of publicity in the case. So this case may require a different level of what is reasonable steps in this case may be different from what is reasonable steps in another case. What I'm asking you is sort of for a paragraph 6, in effect, of to the extent the court, the parties are required to use reasonable steps. This is what the lawyers are required to do under that section of the rule that applies to lawyers, and this is what the prosecutor is being ordered to do under, I think it's 3.8F, and that's what I'm required.
And should we address the range of persons affected by the order, Your Honor? That's really what we're concerned
The range of persons.
Well, it's our strong belief that the people quoted in these, to the extent anyone was actually quoted in these stories, are not people that are in any way connected with the investigation, not people subject to our control, not people subject to whatever types of internal orders we might impose. So will we have the opportunity to address the range of persons?
The range of persons is defined by the rule. I am not expanding the rule nor contracting it. You are not limited to persons in terms of informing people solely under your control. The rule states that you must exercise reasonable care, this isn't the court's language, to prevent investigators, law enforcement personnel, employees, or other persons assisted or associated with the prosecutor. That is the range, and I will not expand nor contract from that range, which is in our rules, and to which you've already agreed on several occasions you would be bound by. That rule has been held in cases to apply even when persons are not under the direct supervision of the prosecutor. So the scope of it is persons assisting or associated with.
Your Honor, January 8th be the date for submission by the defense?
January 8th, you want to both have the same date in terms of, or do you want a chance to respond to theirs as well? And why not do an additional week?
To see
Sure.
defendant's submission and respond on the 15th?
January 8th for defense submission of a new proposed order, 1 through 5 plus, and January 15 for the Commonwealth to respond to its, to any comments it may have on the defense proposal and to any proposed order that it wishes to suggest.
The schedule's fine with us, Ron. Thank you.
Now, have you been able to do a pretrial conference report? Are you ready for that today?
No, Your Honor.
Are you ready to be able to do that today?
Your Honor, I guess if I could, I'd like to update the court on the status of discovery, because I think that's relevant to the pretrial conference report, and to state some of our concerns with discovery. Back on October 9th, the court set December 6th as the deadline for automatic discovery to be provided by the Commonwealth, pursuant to Rule 14. It's now several weeks past that date. There are many, many things we don't have which are required by Rule 14. I sent, the defense counsel, Your Honor, sent 1 week ago a letter to Mr. McCauley itemizing 55 items which we don't have and which we need. Our hope, Your Honor, is that we can get a response from the Commonwealth, that they'll be willing to give us that material so that we won't need to come to the court and take up the court's time with discovery motions. If we don't get the materials we need in a timely fashion, I do want to alert the court that we will have to file discovery motions to obtain that material. And that material includes, among other things, Your Honor, let me just mention one item. We basically have no forensics in this case yet. In a conference call with the prosecutors on October 8th, they told us we would have forensics, meaning reports and backup material in such fields as ballistics, anything they did with footprints, anything they did with DNA, all of that kind of critical evidence within 30 days. We didn't get it within 30 days. We didn't get it as required by Rule 14, by the deadline for automatic discovery, and we still don't have it. And frankly, Your Honor, there's so much we cannot do on the defense side to prepare for trial, to begin to prepare for trial, until we understand what it is the Commonwealth is alleging in the way of forensic evidence, if anything, so that we can prepare to combat that evidence. So I know the court's interested in moving the case forward. So are we, but we really can't move the case to the next stage, Your Honor, until the discovery we've requested has been completed.
And when is that likely to be?
Your Honor, as we've received that materials, those have been forwarded. There are outstanding materials which we've been working to get, including all the notes and the photographs and the other related
So
materials.
you don't have any forensic material yet?
Well, the forensic material we do have what has been sent. So yes, we have sent forensic materials.
And when do you expect to have this by? I mean, to the extent this, and normally we would do a final, a pretrial hearing by sort of February, March. It may be difficult to, at which point we would hear all non-evidentiary motions. It would sound like it may be difficult to do that. When do you think that you're going to get?
Your Honor, it's hard to say. We've told everyone to get us their report, so we're working on that, and I would hope we'd have that in the next 30 days.
So everything you have that is automatic discovery, you provided, and you're saying there's a...
Correct, Your Honor.
Well, for example, Your Honor, I don't know whether they've received any information on jail calls, for example, Mr. Hernandez. Are they listening to Mr. Hernandez's jail calls? Do they have discovery about his jail calls? There's a long litany of things, Your Honor, that we've requested involving, and of course, under the rule, we're entitled to material involving co-defendants,
right.
Statements of co-defendants. Mr. Ortiz, we know, has made a number of statements.
Have you been provided those?
I'm sorry, Your Honor?
Have you been provided with those?
Only the ones that he made initially back in June, Your Honor. We have not been...
And are there no other statements of Mr. Ortiz other than in June that the Commonwealth has?
I've had conversations with Mr. Sultan about additional conversations. So I've apprised him of those, and those are to be reduced to writing.
Do you disagree with the entitlement of any of the 55 on that list?
Yes, Your Honor. There are certain things that are requesting things that we don't have custody and control over, particularly as relates to a matter in Boston. And I said to Mr. Sultan before we start today, I'd like an opportunity to, there's a number of things that we've already provided in that list, and it seems to make sense that we would discuss that further and identify those things that are outstanding, because it is sort of a blanket motion as to many materials, and I know we've provided them thousands of documents, and I presume most of which have would satisfy the requests they're now making.
I don't believe that, Your Honor. They have presented us with thousands of documents, but I don't believe, and I'm happy to provide the court with a copy of the letter if the court wants it.
Why don't, I think it makes more sense for the two of you to meet.
I think it does too, Your Honor.
And go through that list one by one.
That's fine.
1 through 55, see what you may already have been provided, what hasn't been provided but is coming, or what hasn't been provided and is not going to be provided because...
We're ready to do that anytime, Your Honor, and after the
And
court
why not,
wants...
before you leave today, you set up a date to do
Yes, Your
that. And then if there needs to be a discovery motion, we'll schedule that hopefully at the same time as the pretrial conference. You can do a pretrial conference report. It sounds like it may be premature to try to schedule the filing of non-evidentiary motions.
I think it is, Your Honor, until we're completed with the discovery process, because we really don't know what we're dealing with. But that of course, once discovery is complete, certainly I think setting those dates would be absolutely appropriate. But we're not prepared to do that today if the court can.
So do you think it makes sense to schedule a hearing on pretrial conference / discovery motions for the first week of February?
Yes, Your Honor. That sounds fine.
Mark, can I see the calendar? Just having the clerk check my schedule.
Any day but Friday the 7th would work for all defense counsel, Your Honor.
Fourth or fifth?
That's agreeable, Your Honor.
Do you have any preference for Tuesday or Wednesday?
How about the 5th, Your Honor? Wednesday?
Fifth at 2:30. If there is to be any filing, a discovery motion, contested discovery motion heard on that date, I would just ask you to file anything by January 29, and any Commonwealth opposition by February 3rd, so I can review it before the hearing. And if there's anything else that you anticipate being taken up other than the discovery motions, filed in that same time frame. Other than that, we'll try to get a pretrial conference report executed at that time, and schedule, hear any discovery motions and schedule any dates for the filing of non-evidentiary motions and for hearing on the non-evidentiary motions.
That's fine, Your Honor, thank you.
Thank you. Anything else either of you wish to take up today?
No, thank you, Your Honor.
Thank you. Thank you very much.
Court all rise. Let's go to stand and recess.